Is just having a will good enough? In other words, is that an estate plan? Well, no, it is not. What is a will? A will is a document that says where your assets go when you die. And a will is something that most of us are familiar with, whether you're an estate planning attorney or not. You know that a will says this is where everything goes when I die. What it doesn't include are certain things that you should be thinking about for other assets. What happens to those when you die? I'll talk about those in a minute. But more importantly, a will is not an estate plan. It is one component of it. What is more important, in my view, as an estate planning and elder law attorney, is that you have what are called durable powers of attorney. What those documents are, and they're part of your estate plan, those documents protect you while you're alive. When I say protect you from what? Well, we're all familiar that accidents happen, strokes happen, things happen to people where they become incapacitated and they just can't take care of themselves, and they need to rely upon someone, usually a family member, to help them make decisions, to manage their finances, to do all those things. And frankly, if that were to happen, of course, we most likely would want a trusted family member to step in and help us. But if you don't have in place the important estate planning documents called durable powers of attorney, your family member won't have that authority to step in and help you. Instead, what will happen is you would be declared a ward of the state, and the court, through a court-appointed guardian or a conservator, is managing your affairs. And that is a court proceeding. It is something that is expensive, it's burdensome, it is, believe me, if you have ever dealt with a court-ordered guardianship, you'll appreciate what I'm saying. It would be far better, instead of getting the state, the court involved in all those expenses, to instead have signed a durable power of attorney while you were capable and competent during your lifetime, to say, I want this trusted family member to help me out if I can't do things myself. So when you're talking about an estate plan, it is not one document. Frankly, in my opinion, it's not all the documents. It's not durable powers of attorney for finances, for health, your health care directive, your will, your beneficiary designations. Those are all pieces or components, documents within an estate plan. But an estate plan really is the documents plus the knowledge, the guidance, the understanding of why do you have these documents and what do they do for you and do they protect you? Let's go back to where we started when we were talking about what's a will. Is that an estate plan? No, it's a piece of an estate plan. But even if you have a will and all these other documents, you might not have a good estate plan. Why is that? Did your estate planning attorney talk with you about assets and how you have them titled? Did the estate planning lawyer talk with you about your jointly titled bank account? Maybe you put one of your children on your bank account. You want it to go equally to your three, but you thought it was a good idea, and so did the bank perhaps, that you put one of your children on as an owner of this account, a joint owner with you. And what's going to happen on your death? That one child is the owner of that bank account. Are they going to share? Maybe, maybe not. Maybe there'll be litigation. How about your life insurance policy, your IRA or your 401k? Those documents, those assets need what's called beneficiary designations on them. So for example, if you have a life insurance policy and it's $100,000 and you want it to go equally to your 3 kids, you don't want it to pay to your estate to go under your will for multiple reasons. You don't want it subject to creditors' claims because it's exempt from those, etc. You want a beneficiary designation that says it's going to pay to my 1, 2, 3 children. Same thing with your retirement accounts. You do not want those to pay to your estate. they pay to your estate. They have what's called a 5-year required minimum distribution rule, whereas if you pay them to your children as the beneficiary designation, paid to the 1, to the 2, to the 3, then they are going to have a 10-year rule for their required minimum distributions to take from your retirement account. So there's all sorts of complexities that go into estate planning, none of which anyone would ever expect a layperson or even somebody who is involved with other areas of law to understand. So a will is a good place to start, especially if that's where you're thinking it's like, I need a will. Yes, you do. You do need a will, and you need these other estate planning documents, and beyond that, you need the guidance of an expert so that you understand what is the right estate plan for you and you get that plan in place.